Hello and welcome to the Minimum Competence episode for Tuesday, July 23rd, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have the Ninth Circuit's case management system as a model for federal courts, a New York judge's ruling on attorney misconduct cases, DraftKings non-compete clause, X-Corp's trademark lawsuit, and the IRS's need to improve cryptocurrency tax compliance. Let's remember, memory's images, once they are fixed in words, are erased. And read today's legal news. On this day in legal history, July 23rd, 1840, the British Parliament passed the Act of Union, a pivotal piece of legislation that led to the creation of the Province of Canada. This act merged the colonies of Upper Canada, present-day Ontario, and Lower Canada, present-day Quebec, into a single entity. The Act of Union was a response to the political unrest and demands for reform that had been growing in both colonies, particularly after the rebellions of 1837 and 1838. The Act of Union aimed to unify the administrative structures of the two colonies, addressing inefficiencies and fostering a more cohesive government. It established a single legislative assembly with equal representation from both regions, despite significant differences in their population and cultural backgrounds. This structure was intended to assimilate the French-speaking population of Lower Canada into the English-speaking majority of Upper Canada, though it often led to tension and conflict. Taking effect on February 10th of 1841, the act marked the beginning of a new political era in Canadian history, laying foundational governance structures that would influence future developments leading up to the Canadian Confederation in 1867. The province of Canada would eventually split into the separate provinces of Ontario and Quebec, but the Act of Union remains a significant moment in the evolution of Canada's political landscape. The Ninth Circuit's updated case management system is being used as a model for the federal judiciary's administrative office to modernize its electronic filing program, according to Chief Judge Mary Murgoya. The U.S. Court of Appeals for the Ninth Circuit is collaborating with the Administrative Office of the U.S. Courts to replace the CMECF system with a new cloud-based system by the end of 2025. This modernization effort aims to enhance the efficiency of filing legal documents and accessing case information. Since October, the Ninth Circuit has processed all new cases through its appellate case management system, with older reopened cases still using the previous system. This development was a joint effort with the Second Circuit. Judge Murgoya noted a significant decline in case filings over the past 5 years, with the Ninth Circuit now having fewer than 7,000 pending cases, a 23% reduction from the 2019 and the lowest number in decades. A New York appellate judge has affirmed that individuals who file complaints against attorneys in disciplinary cases have a First Amendment right to attend related hearings, view pertinent documents, and access some final decisions. This ruling emphasizes the importance of public scrutiny in holding judges accountable, particularly those serving 14-year terms appointed by elected governors. The decision, issued by Judge Victor Marrero of the U.S. District Court for the Southern District of New York, specifically impacts the New York Supreme Court's Second Appellate Department, which disciplines attorneys based on recommendations from the Attorney Grievance Committee. Judge Marrero asserted that transparency is essential for public trust in the judicial process. However, he allowed an exception for dispositions made by the chief attorney whose role involves preliminary investigations. Those do not need to be made public to maintain investigation flexibility and protect attorneys from baseless accusations. The case originated from complaints filed in 2021 against attorneys in the Queens County District Attorney's Office. Despite these complaints being publicized online, none resulted in public discipline. The plaintiffs argued that public access was necessary, while New York City's former Corporation Counsel claimed it was misuse of the process for political gain. Marrero dismissed presiding Judge Hector LaSalle's defense of legislative immunity, ruling that withholding information is not considered policymaking. He also refuted the state's claim that providing access to certain records would necessitate a substantial overhaul of court operations, stating that procedural adjustments, even if cumbersome, are not illegal. The First Circuit appears likely to uphold a non-compete agreement against the former DraftKings executive Michael Hermelin, who sought to join rival sports betting firm Fanatics. During oral arguments, Judge O. Rogerie Thompson questioned why California's worker-friendly policies should outweigh Massachusetts' business protections. Hermelin, who relocated to California, argued for the state's ban on non-compete clauses to apply. However, the contract stipulates Massachusetts law, as DraftKings is based there. DraftKings accused Hermelin of violating the agreement by joining a competitor and stealing company secrets. Hermelin's legal team contended that California's interest in attracting workers should take precedence. Conversely, DraftKings counsel argued that state laws are equal and California's stance should not override Massachusetts' policies. A federal district judge previously prohibited Hermelin from working for competitors, dismissing his reliance on California law. This case arises amid the Federal Trade Commission's broader move to ban most non-compete agreements, although senior executives are currently exempt. Hermelin's attempts to establish California residency involved leasing an apartment, buying a car, and other actions. Massachusetts law typically enforces contract terms unless they violate public policy. Hermelin's counsel asserted California has the most substantial interest in this matter, urging respect for its policies. However, Judge William Cayetta expressed concerns about prioritizing one state's laws over others in similar circumstances. DraftKings attorney warned that ruling in favor of Hermelin could enable others to evade contractual obligations by relocating to California, stressing the need to protect Massachusetts businesses from such tactics. DraftKings also alleged Hermelin's residency claim was a ploy and accused him of downloading sensitive files before departing. Elon Musk's social media platform X, which is formerly Twitter, is being sued by the PR firm Multiply for trademark infringement. Filed in a California federal court, the lawsuit claims that X's use of the X trademark for social media marketing services causes consumer confusion and infringes on Multiply's established trademark rights. Multiply's spokesperson accused Musk of stealing their established identity and stated the necessity to protect their mark in court. X rebranded from Twitter to X last year under Musk's ownership. This rebranding has already resulted in confusion among Multiply's clients who overlap with X Corp's clientele. Multiply, which has worked with brands like Arizona, Corona, and Liquid Death, adopted the X branding in 2019 and holds a federal trademark for its X logo. Multiply is seeking an injunction to stop X Corp from using the X trademark and is asking for monetary damages. This lawsuit is one among several, as other companies, including X Social Media, have also filed infringement claims against Musk's rebranded platform. The case is DB Communications LLC, doing business as Multiply v. X Corp, and that's in the U.S. District Court for the Northern District of California. In my column this week, I discussed the pressing need for the IRS to bolster its cryptocurrency compliance measures to close the crypto tax gap and combat illicit activities. Cryptocurrencies are often used for illegal activities, and many tax evaders in the crypto space prefer to remain anonymous to distance themselves from their actions. A recent report from the Treasury Inspector General for Tax Administration, or TIGTA, highlights significant gaps in the IRS's cryptocurrency tax enforcement. By improving compliance, the IRS can enhance transparency in financial transactions, address the crypto tax gap, and reduce illegal activities facilitated by digital currencies. Enforcing cryptocurrency taxes could yield substantial revenue and mitigate black market activities that harm the economy. Despite the potential benefits, the IRS's current efforts are inadequate. The TIGTA report notes that the IRS investigated only 390 cases involving digital currency between 2018 and 2023, with just 224 cases recommended for prosecution. The IRS's broader operation, called Hidden Treasure, has focused more on training and tool acquisition than on actively pursuing crypto tax evaders. The use of digital currencies has exploded, with over 26,000 different types and a total market value exceeding $1.7 trillion. Estimates suggest that 21% to 40% of U.S. adults have owned some form of virtual currency. Yet auditing just 390 files is like pulling a few blades of grass from an acre and assuming a complete understanding of the field. Enhanced cryptocurrency compliance can significantly disrupt illicit activities reliant on digital currency anonymity. Cryptocurrencies are linked to crimes such as drug trafficking and human trafficking, ransomware, and terrorism. The IRS's $625,000 bounty for cracking the anonymity of Monero underscores the value of identifying cryptocurrency tax cheats. The IRS needs a coordinated approach to data sharing and analysis, leveraging artificial intelligence to handle vast datasets and uncover patterns. Financial or asset tracing, previously unfeasible on a large scale, becomes possible with advanced technology. Form 1040 already asks filers about digital assets, and this data should be cross-referenced with information from exchanges and audits, focusing on high-income individuals for maximum audit returns. The TIGTA report emphasizes the urgency for the IRS to develop comprehensive compliance strategies, employing advanced data analytics and collaborating with blockchain analytics firms. The IRS must also work with other agencies to curb illegal cryptocurrency activities. While individual cryptocurrencies may remain untraceable, large transactions leave traces in the traditional banking system, providing crucial data points for analysis and inroads to the illicit activities. The IRS has ample information on digital currency holders, but may lack the context needed to connect taxes owed to individual taxpayers. Contextualizing existing data is key to closing the crypto tax gap and disrupting criminal enterprises reliant on cryptocurrency anonymity. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We would sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email newsletter form. We'll see you back here tomorrow, and until then, remember, each city receives its form from the desert it opposes.